the shift from a moderate separationist approach to an anti-separationist approach has been reasonably extreme since June 2022. There's a few possible forces that explain it. Certainly the passing of Justice Ginsburg and the manipulation of the process by Mitch McConnell and Donald Trump to replace an appointment very quickly, with that appointment being Amy Coney Barrett, has, I think, been a big part of it, in that now the majority on the court doesn't need Justice Roberts to do anything. Although Roberts tends to be part of this, on religion cases, he tends to join the anti-separationists. And in fact, in Carson v. Macon, which is one of the two big June 2022 decisions, he actually wrote the majority opinion. But I think that the shift is a shift in the court's view of the world. In the book I'm writing now, one of the things that I point out is the current court has almost an obsession with a narrative that paints Christian social conservatives as victims. Because of that, I'm not saying they're doing this to be mean or anything, but they seem to be completely incapable of understanding the impact of their decisions on religious minorities, whether Christian or non-Christian. And most importantly, this is problematic because they're not following precedent, right? Perhaps you could follow precedent and it may have an impact here or there that isn't beneficial to religious outgroups. But when you are changing 50, 60 years of precedent overnight, and then you are doing so in a way that is privileging dominant Christian social conservatives, it is a much more extreme change than it would be if you were just following precedent and you happen to have a decision that goes in that direction. And the chapter I'm doing based on my talk here, I talk about how the moderate separationist court in the early 2000s, some of their decisions favored government support for religion, like the voucher case, Zelman v. Simmons Harris. Others, like Santa Fe v. Doe, one of the school prayer cases, that supported a more separationist approach. But the current court, whether on a free exercise of funding, religious expression, they seem to always favor the dominant social conservatives, to the point where in some cases they've completely, like in Kennedy v. Bremerton School District, they literally distort the facts to a point where I think a lawyer would have been disciplined. They fail to cite precedent that's on point, something for which a lawyer could be disciplined. I think the extreme shift can only be accounted for by, and I don't mean this in a nice way, in a political shift on the court. And I've always avoided that. I am somebody who, through it all, despite being critical of some decisions or whatever, up until very recently, always believed in the court. They could create a decision that I thought was terrible, but I still believed in the process of the court. I still believed that they were doing law and that there was some level of balance. In the last few years, because of the religion as well as some other decisions, for the first time ever, I've lost faith in the court as a legal body. And that's a painful thing for me to say. It hurts to say that, but they're not really doing law anymore. They're doing politics and covering it up with law. And that's a real concern, because we've always talked about that. It's the legal scholars, we love to talk about, oh, well, that's political. If it goes against, that's being very political. The Warren court was political, or the Rehnquist court was political. But in the end, they were kind of open about what they were doing. Yes, they maybe were activists, but it was a very different thing than we see today. Yeah, so the reason that Smith is not based in separation, I mean, there's the obvious answer, which is there's only one justice in the Smith majority who even really believed in any form of serious separation, and that was Justice Stevens, who remained pretty silent, but I suspect that's why he joined the majority. Nobody knows, but I suspect that's why he joined the majority. But certainly Justice Scalia, who wrote the opinion, was no big fan of separationism, and there's not a word about separationism in the majority opinion in Smith. And you know, basically there's really nothing in the opinion that says it's based in separation. It seems to be based in this notion of, you know, everybody's got to be bound by the rules and you have to rely on the political process for exceptions, which is, I think, very harmful to religious minorities. And it's harmful. Smith has had horrific impacts for religious freedom generally, not just for religious minorities, but for everybody. And so, you know, one of the things I point out in the paper is that I think one of the reasons that, for example, the current court is able to characterize some of the moderate separationist eras as maybe somehow being hostile to religion or something like that is because it kind of coexisted with Smith, which genuinely, I think, was hostile to religious freedom writ large. But Smith comes from a different place. The fact that they coexisted at the same time doesn't mean they're based in the same thing, right? Now, there are certainly separationist arguments. Marcy Hamilton, for example, and other people have made separationist arguments for the results in Smith, but the Smith court did not rely on those arguments. And I think there's equally strong arguments from separation against Smith. You know, I think you see some of that from one of, you know, Douglas Laycock, for example. You know, and Douglas and Marcy, you know, clearly have for many years disagreed on these issues. They're both great scholars, but they have very different views on religious freedom, but they both support some modicum of separation. And so, I mean, I do think there's separationist arguments that could support Smith. Those were not the arguments the Smith court used. And there were also separationist arguments, at least moderate separationist arguments, that could work against Smith. It's an interesting question. I mean, I do think the court will overturn Smith at some point. Now, I do think Justice Coney Barrett, in her concurrence with Justice Kavanaugh in Fulton v. City of Philadelphia, points out, well, what are we going to do if we overturn Smith? Are we going to go back to Sherbert, which was frequently applied in a way that was not favorable towards religious freedom in a lot of cases, you know, particularly for non-Christian religious minorities, but even for many Christian religious minorities. You know, I do think there's going to be a need to answer that question to overturn Smith. I also think that while 15 years ago, the progressive, if you want to call the what people call the liberal wing of the court, I mean, I'm not sure I mean, I think historically speaking, they would be considered moderate. But basically, that wing of the court for a long time supported overturning Smith because of its harm to religious minorities. But now there's a concern that after Hobby Lobby, if Smith gets overturned, Hobby Lobby could become constitutionalized. And that would be something that is I think, a big concern. Whereas RFRA, it's possible eventually to redefine the definition of person to not include larger for-profit corporations, even if they're closely held. You know, I mean, I think that you're not going to get Justices Kagan, Sotomayor, or Jackson to join an opinion overturning Smith, even though if those same justices were on the court 15 years ago, they very well might have supported that pre-Hobby Lobby. But I do think among the other six, if they work out the questions that Justice Barrett raised in her Fulton concurrence, I do think Smith will likely get overturned. I actually fear that could constitutionalize Hobby Lobby, and that is a big concern. I think, it's not a guarantee, but with the current court, I think it's pretty close to a guarantee. And for a number of reasons I've written about, including in the BYU Law Review, I do think that Hobby Lobby is damaging to religious freedom. And if you constitutionalize it, wait 20 years and you may get a constitutional amendment, and that could have a very negative impact on the free exercise clause. You got to be careful what you wish for in today's politics when you're thinking about the long game of religious freedom. In terms of separation, I do think that would be, no pun intended, I think that would be separate from separationism. I think we saw for many years pre-Smith, in the 1960s, 70s, 80s, where, exceptions to laws of mandatory exceptions to laws of general applicability lived side by side with separation quite happily. It was more of a moderate separation. In the 80s, we had 1975 to 1985, we kind of had what might be called a ridiculous expansion of separation to where, you got the cases where you couldn't even have, services for educationally disabled students on campuses. They had to go to trailers. I mean, I'm somebody who supports separation. I certainly don't support that. And so it did get a little extreme there. And you also had cases where they didn't find, like Ling, where they were building a highway. They were going to build a highway through Native American burial grounds, and they said, well, we're not applying the compelling interest test from Smith because the government, can order its own affairs, and they don't have to give an exception there. And so there were cases that really pushed on both separation and free exercise during that period. But if you look at the 60s through the 80s, as a general matter, in a pre-Smith world, separation and reasonably robust religious freedom, at least at the lower court level, coexisted quite well. I certainly think the way they decided Mahmoud v. Taylor fits that trend. The Oklahoma case is an interesting one because it's just a one-line opinion where they say, we're going to let the lower court order stand. I still don't completely understand why they granted cert in that case. The case was decided on independent adequate state grounds. The Oklahoma constitutional provision that prevented the funding for a religious public school, A, was not a Baby Blaine amendment, and B, the Oklahoma charter school law was certainly not a Baby Blaine amendment. So, so it obviously wasn't even a constitutional amendment. So there were clear independent adequate state grounds there. When they granted cert, the question is, are they going to expand Carson v. Macon and say, well, like in Carson, if you give an exemption, if you give funding to a private school of any kind, you have to give funding to a religious private school, even in a state like Maine where those private schools are essentially substituting for public schools. So the question is, were they granting cert so they could then expand that to charter schools? I mean, there's a fundamental problem there because Carson v. Macon very specifically said, we're not talking about public schools here. Public schools are different. So Carson doesn't give you a free exercise leg to stand on for religious charter schools, at least in a state like Oklahoma, whereas the Oklahoma Supreme Court said charter schools are by their nature in Oklahoma public schools. And so I don't know why cert was granted. I suspect one of the reasons they just decided not to decide the case was probably folks realized, yeah, why are we granting cert in this? If the majority went the way they probably wanted to go, it would backfire immensely, because now you're essentially saying if you have public schools, you've got to include funding for religious schools because the charter schools are public schools. Maybe they could draw a line and say, well, the charter schools are under contract. But even then, that this you're trying to bootstrap a contracts argument into what is really an argument about requiring religious public schools. It's not that wasn't really what it was about. It was a really clever legal attempt, but those arguments would have been laughable 10 years ago, but we didn't have Carson v. Macon 10 years ago. I think the Oklahoma case is interesting, but we just don't know. It doesn't support a particular trend. Mahmoud v. Taylor, I think, does. And the reason for that is not necessarily that the case was wrongly decided, but the way the court talks about the books, I'm not sure they actually read the books. I am not sure. It makes me wonder if Justice Alito, who wrote the majority opinion, actually read those books, because those books are not what he seems to think they are. They're in the appendix to the case, because the dissent put all the books in the appendix, the full text. It may be his worldview of what those books mean, but that's the problem with the current court. One of the things I've argued, not in the paper, but in a law review article I wrote and in a book I'm writing now, is that this court is more unaware of its preconceptions than any court in modern American history, probably any court going back to the Lochner court, where its preconceptions obviously were based on laissez-faire economics and so forth. I mean, this court substitutes social conservatism for laissez-faire economics, and we're in the Lochner court again. It's remarkable to me the way the court characterizes these books. It doesn't mean the court's legal reasoning is inherently wrong, right? What it does suggest is, what I've heard from a lot of people is in the field and in more broadly, just general people, is, I'm not so disturbed by the legal reasoning in Mahmoud v. Taylor. They really did overdo the extent to which Yoder was based on parental rights. They really did kind of fudge that a bit. I mean, certainly parental rights were relevant in Yoder. I don't think they were the main thing in Yoder. But, but it's the fact that it's this court, the court that decided Kennedy, that decided Dobbs, that decided Carson v. Macon, that decided all these cases, Brunig, that uses history and tradition and then does a terrible job with history and tradition, or uses it in Kennedy and doesn't apply it, when Kennedy would probably lose under history, and Coach Kennedy would lose under history and tradition because he'd be viewed as a buffoon or sacrilegious throughout most of U.S. history. I think there's suspicion that this court, I don't think people trust this court when it comes to issues involving social conservatism. We're seeing the same thing in the literature on presidential immunity, that people don't trust this court. And I think the way they wrote the Mahmoud v. Taylor opinion feeds into that. And it feeds into the privileging dominant religions, portraying dominant religion in one way and ignoring the other side, or minimizing the other side to a point where it doesn't matter. I mean, I think the school board did have a decent argument here in that these books were integrated throughout the curriculum. So it would have been kind of a nightmare to be able to send notice to the parents when the teachers in every classroom happen to reach that particular point in the semester. Now, I also think the court was probably right that the parents' rights to religious freedom very well may be more important than the state's. I don't think the court acknowledged it was really a compelling interest. Let's assume it was a compelling interest. There are certainly other ways to deal with that, right? There are ways to give notice. There may be ways to have teachers line up when they're doing those books so one notice can be sent out to the parents. And so I think the reason I think the case feeds into the narrative is because I remember when I first read the opinion, I'm like, yeah, well, the court certainly didn't hide its love of social conservatism in the way it portrayed the facts. And I don't think this court is aware. I mean, you look at the Kennedy case. I mean, those are not the facts of the case. If you go back and look at the record, I mean, the dissent put pictures of what really happened in there. And so, you know, this court, I think it feeds the narrative because people don't trust the court. And they just see it as, well, they're privileging social conservatism here, and that fits the narrative. If this had been, if this had been a different situation, and parents were objecting to the Bible, I mean, the Bible wouldn't, let's say it was the Bible as history, not as, well, Bible has a lot of sexual content in it, some pretty graphic sexual content in it. I don't think this court would react the same way if a parent said, well, I want an exception because I don't want my child exposed to the sexual content in the Bible, and they base that on their religion, which is not maybe a religion that adheres to the Bible or whatever. I mentioned Justice Barrett's concurring opinion in Fulton, and I do think it shows she charts a bit of her own path. Also in the presidential immunity decision, you can see that she is charting a bit of her own path. The problem is on the Establishment Clause decisions. She's silent. She just joins the majority, particularly in Kennedy, which is almost like a legal abomination because of what it does to the facts. I guess a factual abomination. And I haven't seen any indication that she's like a Justice Douglas who kind of went from one place to the other on both religion clauses. I haven't seen any evidence to suggest that, but there is evidence to believe that she certainly doesn't, it is not inevitable that she will follow the Alitos and Gorsuches and Thomases all of the time. But I haven't seen any indication that that she or Justice Kavanaugh, who also could theoretically be someone who could create some movement on these issues. I haven't seen any evidence on Establishment Clause cases that either of them are going to leave the six, so to speak. But I do think maybe in the free exercise area, yes, that is possible. So I tend to look at religious freedom and separation issues from a religious pluralism perspective, so civil rights as well as civil liberties. But I think whatever perspective you come at it from, accommodation is, as a general matter, I think a pretty good idea. I think Cole Durham's loop model gives us some very good examples as to why. Now, there are levels of accommodationism. I think that overturning Smith or having a RFRA that doesn't include large for-profit companies as persons is good because the reality is that general laws are going to interfere with religious practices. I think Justice Scalia got it exactly backwards in Smith. He says, well, the political process is there for groups to try to get an exception. But the whole reason groups weren't considered when the initial law was passed is because they don't have the numbers or power to be considered, or maybe they're not even known about. And it becomes very hard for them to be able to lobby and do, particularly if it's an unpopular group, and do what's necessary in the political process to get religious exemptions. So I think that accommodation in the context of religious exemptions is a good idea. I think the court has pushed the concept way too far in the area of funding, where you're mandating funding. You're not saying you may fund vouchers anymore. You're saying you must fund them if you're funding anything that's non-religious. I think that's not accommodation anymore. That's promotion. But and I think moderate separation also works well for religion. Again, you can look at Durham's loop model. If you look at the loop, you've got accommodation here, you've kind of got separation here, but they're both towards that sort of ideal end of the loop, if you can call anything an ideal end of the loop. And I think moderate separation may just literally be right across from, because there's all different kinds of separation. And moderate separation doesn't mean you have to be hostile to religion. It means you can acknowledge that there are many people in society living their religion. It just means that government should not be doing religion. Government should not be promoting religion, and government should not be favoring religion. It doesn't mean they can't treat religion the same as other entities if they want to, but it also shouldn't mean that they have to fund religion, that, for example, my taxpayer dollars, if I live in Maine, might have to go to a school that is going to be teaching children how to try to convert my children who are a different religion. That to me, moderate separationism combined with accommodationism gives us a reason why, Coach Kennedy probably should have lost based on the actual facts, not based on the facts as the court stated they were. I mean, if he really was engaged in private speech at the 50-yard line and it was quiet and wasn't calling much attention to himself, and it's anybody can do anything after the game. If that was the case, if that's really what happened, he would have won under the prior. He would have won even when Lemon and endorsement were still good law. There was no reason to overturn 50 years of precedent. Of course, those were not the facts. This guy was not, I mean, there's not just the pictures in the dissenting opinion. You have to go back and look at the record. I mean, this guy was not quiet. He was nothing like what the majority characterized. I mean, he was having practical revival meetings after the games, complete with religious speeches. And then he called the media attention to it. This guy would lose under moderate separationism because the school would have a right to hear. It would be a compelling interest for the school. And they gave a more narrowly tailored option, which is when your coaching duties are over, we welcome you back to the field. He had basically been the one who got rid of the other potential narrow tailoring, which is, just go be quiet and do it the way that you say you want to do it. But that's not what you're doing. Same thing with Carson v. Macon, right? You would say, well, Maine can't exclude religious schools because they hate religion based on religious status, but they can exclude religious schools based on religious use. And the Maine rule was clearly concerned with the use. The law in Maine was concerned with taxpayer dollars funding people essentially being trained in particular religion, or potentially being moved towards that religion, as opposed to we hate X religion or Y religion, or we're going to exclude you from a program that provides secular textbooks or something like that, which they couldn't do. And so, I think moderate separationism allows a lot of play in the joints. Prior to June 2022, the court had for over 50 years talked about the play in the joints between the religion clauses, between the concept of free exercise of religion and the concept of separation, that you can have both, that you can have this sort of healthy play in the joints that allows a pretty strong modicum of accommodation, probably would be better without Smith, and a pretty strong level of separation, but not so strong that it becomes inherently hostile towards religion. And together, this allows a maximization of both religious freedom and also freedom for people to not be essentially converted or in a way almost proselytized, even if it's toward a civil religion by government. Because in some ways that's what these things do, or coerced in the case of some of the players in Kennedy. So, I think that accommodationist-separationism is that balance. It's that play in the joints, which says we don't have to deny the right of people to live their religion. At the same time, government shouldn't be telling people how to live their religion or promoting religion.